And greetings, everyone. Welcome to Public Officers, Nature of Office and Employment from American Jurisprudence. Getting all the technology set up here. Give me just a moment. Make sure we get all the chat happening here on the screen. All right. We got Jay in the house. Greetings to you. Here we go. It's not coming up, is it? Just a moment here. Let me, Lord. Let's see here. Trying to bring this, there we go. And just a second here. Let's make this over here too. Give me some moment. I'm going to get chat over here as well. And I just need to bring it in over to here. And there we go. Okie doke. And then I think we need to have it here for the book as well. Shoot. Yep. Apologize for that. Let me get this going here. We'll edit this out later. And I'll throw this guy in here. And that will have the chat visible as well. Thank you for the patience, guys. And we're off. So please make sure you hit the like. And let's get right down to it. We'll have Black's Law Dictionary 2 at our side to make sure we leave no word behind. And with that said, let's get right down to public officers, nature of office, and employment. All right, there we go. Okay, so this is from second edition American Jurisprudence, 63C volume, Public Officers and Employees. And here's our summary. In the scope, this article discusses public officers and employees, including discussions of the general nature and definitions of public office, employment, officers, and employees, on the basis of rights to public office or employment, the manner of creating, modifying, and abolishing public offices, eligibility and qualifications for public office or employment, the manner of acquiring or filling public offices and positions, vacancies in office, and prerequisites to entering public office or employment. Other matters discussed include the terms and tenure of office or employment, termination, suspension, or other adverse employment actions affecting public officers and employees, compensation, liability, actions, remedies, and matters of practice and procedure regarding proceedings involving public officers and employees. So we're going to cover a lot in this, although it's going to move rather quickly. So stay with me and take notes. Give me one moment here. I'm still having difficulty getting this chat up. And yep, there we go. All right, and as long as we get everyone in the house here, go ahead and pipe up in the chat there. Let me know you're all there, and let the algorithm know you're here too, so get the word out to everyone. All right, let's get going here. Numerous federal statutes affect public officers and employees, including provisions pertaining to actions against congressional officers for official acts, civil penalties for criminal offenses by public officers and employees, commissions and oaths, nepotism, circumstances under which the holding of federal positions is prohibited, suspension and removal of federal agency employees for national security reasons, financial disclosure requirements, the Office of Government Ethics, and restrictions on former officers, employees, and elected officials of the executive and legislative branches of government. And we also have other editions of American Jurisprudence, which will treat these other subjects here. But for tonight's presentation, we're sticking with the scope of that summary. So let's get right down to it. All right, so definitions and purpose of the term public office, section 1. So a public office is a position in a governmental system created or at least recognized, by applicable law, to which certain permanent duties are assigned, either by the law itself or by regulations adopted under the law by an agency created under such law and acting in pursuance of it. Now, here's an interesting word, permanent duties. Let's go into blacks and really see what they mean here in a legal sense by the word permanent. And bear with me as we go through this. This is a scanned document, so it takes some time to find the actual word. Here is catching up, but it'll be with us shortly. We'll edit this part out here. In the meantime, it's always nice to glance at some of these words because you kind of miss this with the digital editions usually. But when you're thumbing through that real physical hard copy of Black's Law, you have the serendipitous occasion of coming across words that might come in, helpful later, like obligatio quasi ex delicto, which is an obligation arising from a wrong that is not covered by an obligatio ex delicto, but that nonetheless creates a liability. And that will come into play with actually what we're going over, because obligations and duties here are going to be further illustrated. We'll pass a little bit here. We'll catch back up. Appreciate everyone's patience here. We're just about there. Gosh. All right, here we go. Perm, almost. All right, we got, oh, well, hang on. It's under permanency plan. So it'll be after all this. Permanent. Oh, Lord, don't tell me the word's not in here as is. So I guess we'll have to go with a dictionary definition. Goodness. Well, we could look at, gosh, permanency. Well, permanent abode, permanent alimony, and what was the actual word we were looking here? Permanent employment, permanent injury. Oh, Lord. All right, so whenever we don't have a legal definition, we stick with the dictionary definition or as defined in a statute or code or law. And I don't see it here. Now, there is a similar word, perpetuity, which is the state of continuing forever. So this needs to be distinguished from permanent. An unbearable entail, historical and inalienable interest. For an interest that does not take effect or vest within the period prescribed by law. So it has something to do with the period of law prescribed. In reference to the rule against perpetuities, only sense 4 is now current. The rule against perpetuity. A perpetuity is a thing odious in law and destructive of the commonwealth. It would put a stop to commerce and prevent the circulation of the riches of the kingdom, and therefore is not to be countenanced in equality. If in equity you could come nearer to a perpetuity than the rules of common law would admit, all men being desirous to continue their estates in their families would settle their estates by way of trust, which might indeed make well for the jurisdiction of the court, but would be destructive of the commonwealth. At 1683, for Lord North is quoted by George W. Keaton in English Law, the Judicial Contribution, 1974. Interesting. So that's a nice distinction there with the word perpetuity. And permanent, we're going to stick with dictionary definition. Well, let's get back to the book here. Okay, permanent duties is how they are prescribing this here. Make sure it's okay, yeah. Either by law itself or by regulations adopted under law, by an agency created under such law and acting in pursuance of it. So the law, I guess using the word permanent, would dictate the bounds of the period of the duties assigned. And they're permanent as long as it's within that law period, I guess. We'll find out. Public offices are created for the purposes of government, and they are delegations of portions of the sovereign power for the welfare of the public. They are not the subjects of contract, but they are agencies for the state, revocable at pleasure by the authority creating them, unless such authority be limited by the power which conferred it. That's footnote 2, which is AmJur versus State of Michigan. Appeal denied 2017, so rather current. A public office has also been defined to be the right, authority, and duty created and conferred by law, the tenure of which is not transient, occasional, or incidental, by which for a given period an individual is invested with power to perform a public function for the benefit of the public. Footnote 4, which would be Peoples versus Rosales, and that's 2005 in California. See, a person deemed a public officer, a person will be deemed a public officer if the person is appointed or elected to perform duties of a grave and important character and which involve some of the functions of government for a definite term. And that's Green versus Wolf, 2017 in Pennsylvania. So this is an interesting one. A person will be deemed a public officer if the person is appointed or elected to perform duties of a grave and important character. So they have to be either appointed or elected to be a public officer to perform duties of a grave and important character, not one or the other, and which involve some of the functions of government and for a definite term. A position is held to be a public office when it has been created by law and casts upon the incumbent duties which are continuing in their nature and not occasional, and which call for the exercise of some portion of the sovereignty of the state. Thus, an office is a public charge where the duties are continuing and prescribed by law and not by contract, and the officer holder is invested with some of the functions pertinent to sovereignty or having some of the powers and duties which inhere with the legislative, judicial, or executive departments of the government. Public offices are created for the purpose of effecting the end for which government has been instituted, which is the common good, and not for the profit, honor, or private interest of any one person, family, or class of persons. Footnote 8. 1950, Dean versus Paulicelli. That's Virginia. And here's an interesting observation. In some constitutions and statutes, the term civil office is used and generally defined in a matter similar to public office. So you got to check your state constitution and statutes for that term, civil office. Section 2, public office as distinguished from public employment. There is a distinction between a public office and a public employment. And although every public office may be an employment, one can be a public employee or public servant without necessarily holding a public office. Key thing to pay attention here, public servant, without necessarily holding a public office. Whether a person holds a public office rather than mere employment does not depend upon whether the particular office in question may be called, but upon the power granted and willed, the duties and functions performed, and other circumstances which manifest the true character of the position and mark it a public office, irrespective of its formal designation. Interesting. And that's, Western Dakota Vocational Institute, South Dakota, 1988 versus Seymour. All right, before we go any further, let me just double check on the chat here. Let's see what we got going here. All right, that looks like it. Let's continue. All right, among the criteria to be considered in determining whether a position is an office or a mere employment are whether the position was created by law. All right, so that's among the criteria in determining whether it's a public office or mere employment, public employee. Was a position created by law? Number one on your checklist. Whether the position was designated by an office. Number two. And here's another one. Whether the qualifications of the appointee have been prescribed. And also whether the duties, tenure, salary, bond, and oath have been prescribed or required. And whether the one occupying the position has been constituted a representative of the sovereign. That's some criteria there. Let's see, as from number 5, Kales versus Town of Meadow Bridge in West Virginia, holding that a town sanitary board member was not an officer. Woohoo! That must be an interesting case. I also want to mention that nothing here is to be construed as legal, lawful, professional advice, not to be used for anything financial, professional, personal, or otherwise. This is strictly for the entertainment, educational broadcast on YouTube. Don't do this at home. All right, let's continue. So the one occupying the position has been constituted a representative of the sovereign, and as of the people collectively. And constituted a representative. Important verb here. An office opposed to an employment. An office as opposed to an employment is a position for which the duties are continuing and are created by law instead of contract. So the office as opposed to the employment has duties which are continuing, permanent, right? And are created by law instead of by contract. Again, the public office is not by contract, it's by law. The duties include the performance of some portion of the sovereign power for the public's benefit. Some portion. For the public's benefit, though. And this is footnote 8. That was, Maryland, 2006, 2008. When a person is a public officer, whether a person is a public officer may differ in accordance with the statutory or constitutional provisions under which a given position is being examined. To qualify as an officer of the United States, with the meaning of the Appointments Clause, an example, not simply an employee, a person must exercise significant authority pursuant to the laws of the United States. So again, having that function of government requirement. Moreover, the main criteria for drawing the line between federal inferior officers and federal employees not covered by the Appointments Clause are 1. The significance of the matters resolved by the officials, and 2. The discretion they exercise in reaching their decisions, and 3. The finality of those decisions. Ooh, right, that's pretty good criteria there. That's Tucker versus CIR and DC Circuit 2012. And we have a cumulative supplement for this section. While the Appointments Clause restricts the appointment of officers of the United States with duties in or related to the District of Columbia or the territories, it does not restrict the appointment of local officers that Congress vests with primarily local duties. Ooh. And that's referencing the United States Constitution, Article 4, Section 3, Article 1, Section 8, Clause 17, Article 2, Section 2, Clause 2. Wow, so Financial Oversight and Management Board for Puerto Rico versus Aurelius Investment LLC, Connecticut, in 2020. Wow. So we have some pretty interesting stuff here. If everyone's in the chat, if they could just hit a little something up. I'm not sure if I'm getting this stuff refreshed or not. I should double check and make sure it is. I think it stalled on me. Throw a little something in there and see if it is indeed working. All right, looks like that's coming up, so we should be okay. All right, let's continue. So we're on Section 3, the nature of public office as public trust or agency. A public office is created in the interest and for the benefit of the people and belongs to them. Thus, a public office is a public agency or trust which extends to all matters within the range of the duties pertaining to that office. Here's an observation. A public officer, within the meaning of a statute providing that any public officer convicted of any felony or malfeasance in office will forfeit the office and be disqualified from holding public office, is either 1. Someone in a position of public trust conferred by some authority, or 2. A person authorized by law to discharge the duties of a person in the position of public trust. Since the position of guest chaplain to the House of Representatives, which position lasts as long as the prayer that opens a session of the House, comes with no public expectations of trust, it is not a public office. So I guess you can't trust the guest chaplain. And that was 2017. Interesting. I wonder what was behind that one. All right, we're on to Section 4. Particular characteristics or elements of public office, generally. So here are the characteristics or elements of a public office. Here's your checklist. Its creation by law, that is, by statute or constitution. The designation of the position as an office. The prescription of the qualifications and duties of the appointee. The exercise of some portion of the sovereign power. A permanent or continuing position, not occasional or contractual. A fixed term of office. And having to make an oath and bond. Let's look at these footnotes here. These are interesting. So we had 6 is an interesting one too under permanent. 2002. Right. And we have here having to make an oath and bond, 9 and 10. So 9 is for the oath. That's City of Charleston. Housing Authority of City of Charleston in West Virginia. And we also have the Texas Appellate Court here. In San Antonio, refused. County medical examiner, not a public officer. Interesting. The taking of an oath, while not required, is a strong indicator of a person's status as a public officer. So the taking of the oath is not required according to Indiana law. And then the bond is back to this town of Meadow Bridge in West Virginia, that a bond is part of a characteristic or element of public office. But having to make an oath isn't necessarily required. It may or may not be, it seems, because of this one here, the petition for discretionary review. Wait, this is the oath. Here it is, taking of the oath while not required. There it is, the Indiana law in Hallett versus Hack, 2015. All right, let's proceed. And we've got some chat to check before we do anything further. All right. This actually kind of fits in here. Let's read it. From Diesel, we have interesting statute or constitution when the statute is supposed to be married to the Constitution, the falsifying statute to have authority. Well, that would be, again, a constitutional issue to take up if that was an issue in conflict. All right, so now we're on to Section 5, the sovereign power and the functions as elements of public office. So we're back to the sovereign power function, which was part of our checklist, I believe. Okay, and that would be exercise of some portion of the sovereign power. And of course, it's referring to Section 5. And it's footnote 5. What a coincidence. The power to exercise some portion of the sovereign functions of government is one of the characteristics of a public office, as we saw before. Indeed, the power to exercise some sovereign government function has been called the most important characteristic of a public office. Some authority holds that the primary, necessary, and fundamental test of a public office is that it should involve the exercise of some portion of the sovereign power of the state. The powers conferred and duties to be discharged with regard to a public office must be defined, directly or impliedly, by the legislature or through legislative authority. The duties must be performed independently and without control of a superior officer other than the law, unless they are those of an inferior or subordinate officer, created or authorized by the legislature and in place by the general control of a superior officer or body. Oh, superior. So let's see what this is. That was footnote 6, and that's Matthews versus Murray, 1953 in Nevada. Prohibition against holding multiple public offices generally, see Section 57, and that was footnote 4. Of course, that's a maximum of law. Okay, so yeah, you wouldn't have directly or impliedly if it's two offices. It would be strictly to one office. Public officers authorized by law to independently exercise function of either an executive, legislative, or judicial character. And the exercise of this power by the officer is subject to revision and correction only according to the standing laws of this state, and that was Texas. All right, we're on to Section 6, tenure and duration as an element for of a public office. And let's go over to the chat here real quick. And we have Diesel mentioned here that turn the light, Second Amendment shall not be infringed, but the statute is overriding it, allegedly. Yeah, it seems that way, but a lot of that's being corrected as well. So let's continue here. And it's under the tenure and duration as an element. So the public officers embrace the idea of tenure and duration and a fixed term of office is one of the characteristics of a public office. So it's a fixed term. The duration of office, however, need not be for a fixed period to constitute a public office. The requirement of tenure means that the office itself has some permanence and continuity, and thus a public office may exist even in the absence of a fixed term for a particular incumbent. However, it has also been said that an officer of the United States is traditionally considered to embrace the ideas of tenure, duration, emolument, and duties, which are continuing and permanent, not occasional or temporary. And that's the guest chaplain for the length of the prayer is not in office. Poor guest chaplain, man. All right. And we're on to section 7, compensation as an element of public office, effect of public funding. All right, this should be interesting here. Double check the chat here, make sure there's no further comments. All right, let's continue. Although among the criteria to be considered in determining whether a position is an office or mere employment is whether a salary has been prescribed or required. Compensation is not an indispensable element of a public office. There we go. I love this one here. Compensation is not an indispensable element of public office, meaning that they don't need to be paid for it to be a public office. It's among the criteria is whether a salary has been prescribed or required, but it's not an indispensable element of public office. It may be for employment. The manner in which the compensation of a public position is fixed is not an absolute test to determine whether the position is an office, but is merely a circumstance to be considered. Individuals may occupy positions which are publicly funded and authorized by statute, but this does not compel the conclusion that they are public officers. Wow. As a compensation of public officers, see sections 258 to 285. Wow, that's a lot there. All right. And moving ahead here to public employment general, and let's double check on the, double check on the chat here. These definitions are specific, they are vague and ambiguous. Not too sure how to interpret that one there, but the definitions are trying to remove the ambiguity, and when there is, they're letting you know there's some ambiguity based on statute, and that's the purpose of going through American jurisprudence like this, because it's helping to see the practical elements of these words and how they are actually engaged into action. So from these words and thoughts into action is the intent of going through these documents here and learning about what the essence is of these laws, these principles, and common law. Let's continue. Public employment generally. A public employment is a position in the public service which lacks the required elements of an office to make it such, where, therefore, the position is created not by force of law, but by contract of employment. It does not rise to the dignity of an office. Public policy requires that there be certainty as to who are and who are not public officers, and the same standard applies to public employees. Footnote 3, and that's Champaign-Urbana Public Health District versus Board of Review of Department of Employment Security. Once an officer or employee resigns, the resignation cannot be withdrawn. Officer or employee resigns. Okay, so if either of them, all right, so public policy, there's certainty as who are and who are not public officers. There has to be some certainty to that, and the same standard applies to public employees. So if an officer or employee resigns, the resignation cannot be withdrawn on either of them. All right, understood. That's a good clarification there. And now we're down to the characteristics of a public officer. One who holds public office is a public officer. And where there is no office, there can be no public officer. The question as to whether a person holding a public position is a public officer or merely a public employee is primarily one of statutory powers and duties. Key considerations are the nature of the office, the powers wielded, and the responsibilities which are carried out. Characteristics of a public officer include. Now, we're going to restate some of the things we heard before, but that's one of the things we do in American jurisprudence is having the same concepts repeated in different ways so you see them in a multifaceted way of the actual application and not just in the words themselves. So, in another way of restating it, the creation of the person's position by either a state, constitution, or statute, as well as the prescription of his or her duties and powers by law, rather than by contract. So the creation of the powers, the person's powers, that's the office, right? The public officer, by either a state, constitution, or statute, as well as a prescription of duties and powers by law, rather than contract. So you can't have duties prescribed by a contract for a public position, a public officer, and a requirement of law that such person be elected or appointed. Okay, so these are some characteristics, and a definite or fixed term. We're back to the of employment, back to the tenure. Although they use the word employment, position maybe would be better, but they probably use it from the case. Let's see here, footnote 9. Cohen versus New York State Local Employees Retirement System, 2014. So you could look into that one. It looks like several citations on that case here again and again. All right. So a required oath of office, and that's footnote 10. Cohen, back to the Cohen. So this is an interesting case to look at. Cohen versus New York State and Local Employees Retirement System, and that was 2014 in New York. So that's a good case to look up for further research. The delegation to and exercise of some portion of governmental sovereign power, either legislative, executive, or judicial. So we have some governmental sovereign power of any of the branches here is fine, but with supervisory and discretionary authority. So they got to be supervising and they got to have some discretion as to that power. Importance, dignity, and independence of office are also relevant factors. Boy, dignity. In the determination of public officer status. A public officer exercises a high degree of initiative and independent judgment. An individual is a public officer if any sovereign function of the government is conferred upon that individual to be exercised largely independent of the control of others. Similarly, if the office occupied involves a large degree of independence in which the individual is not under the direct supervision and control of an employer, then the individual is a public officer. So it's a large degree of independence and not under direct supervision and control of an employer, then it's a public officer. Subordination to a superior, however, does not necessarily render a subordinate non-official. While public officials have sometimes been considered employees for specific purposes, a public officer is generally distinguished from a public employee by his or her power of supervision and control, and by his or her liability to be called to account as a public offender in case of malfeasance in office. Again, that's the bond they're referring to. That's footnote 22. And that's Pike County versus State. And that's 1984, Indiana. Let's get back here. So we have an observation here, which is a nice little treat here with American jurisprudence. Some statutes include officers among the definition of employee, just to make it harder. And that's footnote 23, and that's AmJur civil service. So that looks like that's another detailed topic there, civil service. All right, we're on to the cumulative supplement here in the cases. A city police officer was a municipal employee and not a municipal officer, and thus statute barring individuals from serving both as a municipal officer and county officer did not apply to prohibit city police officer from simultaneously serving as magistrate on county fiscal court. Geez, city police officer was not elected to his police officer position, and city did not create the job of city police officer through ordinance that specified title of office, powers and duties of office, oath of office, and bond, as required by statute, to create a city office. Boy, Kentucky. Clark County Attorney versus Thompson. 2021, so very current. Whew, a lot to learn on this one here. Let's see what else we have here. Any footnotes that have further narrative here. Public officers invested by law to perform a function of government, while an employee is not invested by law to perform a function of government. All right, that was a pretty dense chapter there. And we're on to section 10, the characteristics of a public employee. But before we do that, let's hop over to the chat and see what we got here. All right, great. So you got the clarification there. So in short, your representative versus the secretary, the representative. They're not supposed to lie. Yep. Police security guards. Yeah, and they can also be magistrates, it seems. All right, let's continue here. So now we're on to the characteristics of public employee. And this is much shorter, it seems. In contrast to public officers who exercise some portion of sovereign power and are vested with discretionary authority, an employee does not have such power or authority. Indeed, a public employee, in contrast to a public officer, is a person in public service whose duties are generally routine, subordinate, advisory, and as directed. Moreover, public employees are generally responsible for performing ministerial duties. Ooh, observation. While discretionary duties involve personal deliberation, decision, and judgment, ministerial duties are those which are absolute, certain, and imperative, involving merely the execution of a specific duty arising from fixed and designated facts. So the discretionary duties, here's your observation for that distinction. So when people are trying to make a distinction between discretionary duties and ministerial duties, the discretionary duties involve personal deliberation, decision, and judgment. Ministerial duties are those which are absolute, certain, and imperative, just by the book, right? Involving merely the execution of a specific duty that's arising from fixed and designated facts, not discretionary. No judgment or decision involved. It's the execution of duty. Specified. One who merely performs the duties required of him or her by persons employing him or her under an express or implied contract, though such persons themselves may be public officers, and though the employment may be in or about public work or business, is mere employee. Wow. Even they may be public officers. So it's back to the cop that was a magistrate, I think. No, it's a different one. Seymour versus Western Dakota Vocational Technical Institute in South Dakota in 1988. All right, so we're back to that case. So, one who merely performs the duties required of him or by persons employing him or her under an express or implied contract, not prescribed by law, an express or implied contract, and that could be implied too. Though such persons themselves may be public officers, and though the employment may be in or about public work or busyness here, it's a mere employee still, because they're under express or implied contract. The determinative question in assessing whether an individual is a public employee is whether the individual is subject to the direction and control of a public employer. Ooh, footnote 7. Ooh, let's see, Massachusetts, applying Massachusetts law. And footnote 2, which was employee does not have the authority of the sovereign power. And it says here, government has a substantial interest in ensuring that all of its operations are efficient and effective. So government has a substantial interest in ensuring all of its operations are efficient and effective. So when we're checking government to make sure they're functioning in the public interest, then there's a substantial interest in ensuring that all of its operations are efficient and effective. And that interest may require broad authority to supervise the conduct of public employees. This could apply to the people having that broad authority to supervise the conduct of public employees. And this comes from, let's see here, Borough of, okay, I'm not going to read that there. Let's continue. Petition for discretionary review refused, and there's the one applying Massachusetts law. Excellent. Now we're on to section 11, the basis of public office or employment. Let's hop over to the chat here real quick. The people doing the audits, well, a substantial interest of the government to ensure it's functioning efficiently and effectively. And who's going to make sure of that except for the people who's entrusted the government to do that with? It's given them that sovereign power to do such. It's the people's duty, let's face it. While as a general rule, the relationship of employer and employee is a contractual in nature, a public employee does not hold his office or her office ex contractu, that is, pursuant to a contract in the sense of an agreement or bargain between him or her and the public. But rather holds his or her office ex lege as a matter of law or pursuant to the statute. Thus, public employee is generally held and governed by statute, not contract. So the public employment is held and governed by statute, but the contract is similarly. Employees of charter governments work subject to the amendment, revision, or repeal of charter provisions affecting their employment. States, however, may enter into written employment contracts with individuals on specific occasions. States, in the written contracts, employment contracts with individuals. That could be entire businesses. Observation, federal employees serve by appointment, not by contract. And the terms of the appointment displace previous understandings that in other contexts might have created a contractual right. So they made it very clear to displace previous understandings. There is no contractual rights for federal employees. Let's see, public-employee relationship derives from applicable statutory schemes and not from an independent contract between a public employer and employee. So there it is. That's your case law. That was from 1999. And we're on to section 12, the right to hold public office or employment or to be considered for such. Before we do this, let's hop over to the chat real quick. Kind of like the 4D child support contract or driver license quasi-contract. Well, we're getting back into the elements of contract, which permeate through all aspects of our civilization. There is some difference of opinion as to whether the holding of a public office is a right. Some authorities hold that an incumbent generally possesses no vested right to a public office. Such authorities state the opportunity to hold public office is a privilege rather than a right, and hold that there is no fundamental, inherent, or constitutionally protected right to public employment or to hold office. Ooh. Furthermore, it has been said that there is no right to public office unless it is under express constitutional protection, and that a public employee ordinarily has no vested contractual right in the terms of his or her employment, such terms being subject to change by the proper statutory authority. Thus, the states have the discretion to establish certain conditions under which the right to hold public office is determined. On the other hand, some authorities have stated that the right to hold public office is a valuable right of citizenship. And a fundamental right, footnote 10. 9 refers to the Citizenship People Foundation for Taxpayer and Consumer Rights versus Dookie. And that's in California Reporter 2003. When an employee has a vested contractual interest in retirement benefits, this is an exception to the rule that public employment is governed by statute and legislative policy. Interesting there. Pensions, huh? All right, and 10 was Gilbert versus Chang, and that's California also 2014, so more recent. And a fundamental right to hold public office, although there is some authority within such jurisdictions indicating support for the contrary position. Furthermore, some authorities hold there is a fundamental right to be considered for public employment without invidious discrimination or unreasonable limitation. While some authorities hold that there is no right to run for public office nor express constitutional provision guaranteeing any individual the right to become a candidate for public office, appear on the ballot, or be elected, and that no fundamental status has been attached to candidacy, other authorities hold that the right to be a candidate for public office is a valuable right, and that the right to become a candidate and run for public office is a fundamental right. And that's footnote 19. And West Virginia, fundamental right. Interesting. And we had Arkansas versus Chesterfield, the Populist Party of Arkansas versus Chesterfield in Arkansas, 2004. Interesting. So let's look at some of these footnotes here and what they have to say on them. No person has a vested right to any public office or position except as provided by law. And if a competent authority abolishes a position for a legitimate reason, the holder thereof has no remedy, because he or she has necessarily lost the position and the salary which goes with it. That's Arizona. And we're on to there is no constitutional right to federal employment wherever one chooses to live. So I get it. As to rights of civil service employees to their positions generally, see civil service. That might be a good future topic, is to go into the AmJur for civil service. State employees are not vested with a due process property interest in their career positions, referring to the employees of the Commonwealth of Puerto Rico. And when a public employee has a vested contractual interest in retirement benefits, this is an exception to a rule that public employment is governed by statute and legislative policy. So that looks like the only exception I can see here. There may be more. The right to run for public office, and with it the status of candidacy, is not itself viewed as a fundamental right, and that's in Missouri. In the Green Party of Georgia versus Kemp, that was footnote 17. Other authorities hold that the right to be a candidate for public office is a valuable right. So that one was held. Oops. We got to fix that one there. Pardon me 1 second here. All right. Fix that one more time. Okay. All right. All right. Let me get back to where we were here. And if you have any questions in the chat, let's pipe in there and see what we got in the chat section here. Oh, wait, we have a few more here. The right to run for public office and with it the status of candidacy is not itself viewed as a fundamental right, and every voter has a right to be a candidate for public office if he or she possesses the qualifications required to fill the office, and that's in the state of Texas, or Texas. All right. Now we get to section 13, the right to hold public office or employment or to be considered for such. Property rights. All right, and nothing here in the chat yet, so let's just continue through this one and read about the property rights and the right to hold public office or employment or to be considered for such. There is some authority for the view that public officers, properly elected, have property rights in their respective offices, and that one may have a property right in public employment if he or she has an enforceable exception of continued employment or some form of guarantee created by a specific ordinance, state law, contract, or understanding limiting the ability of the state or state entity to discharge him or her. Indeed, the Due Process Clause of the 14th Amendment protects government employees who possess property interests in continued public employment. For example, where an employment agreement provides specific starting and ending dates for teaching responsibilities and sets forth payment for doing so, the employee has a protected property interest in continued employment under state law as required to demonstrate a violation of the employee's procedural due process rights. So, sounds like an issue here where you're what's it called? They're called property rights here. They could be claimed in certain situations as property. These rights here. This would be a loss and it'd be monetized. However, other authority holds that a public officer or public employee does not have a right of property in his or her office or employment, and that an elected office is not a property interest with which an office holder has a recognizable, reasonable expectancy of continued employment, as one might find in an employment setting. There is also authority that a public office is not property within the provision of the United States Constitution prohibiting deprivation of property without due process of law, or within an agreement in a treaty with the United States not to impair the property rights of private individuals. Moreover, the employee does not have a constitutionally protected property interest where the terms of employment give the public employer significant discretion to terminate an employee. And I guess that's why we have such low quality of public employees. An employee had right of tenure. Now, see, this is something that belongs with a public office. County employee possessed property right protected by the Due Process Clause in her continued employment with the County Department of Social Services, where the employee was non-probationary and in a competitive class at the time for termination. As a property interest with regard to rights to continued employment, in order to have a constitutionally protected property interest in one's public employment, the employee must have a legitimate and objective entitlement to continued employment based on ordinances, rules, regulations, or other mutual understandings promulgated by the government. Town of Palm Beach, 11th Circuit, Florida. A due process deprivation of property claim arising from the loss of public employment may be established by reference to a state statute, policy, rule, or contract, and that's Rhode Island. Non-tenured professor, former Army employee. Provisions of a town's policy and procedure manual were not promulgated as legally binding rules and regulations as required for the manual to form the basis of a town's employee's claim to a property right and employment protected by due process, where manual was not a contract of employment. Ooh, interesting. A school's principal's explanation of continued employment in his or her administrative position is not a constitutionally protected property or liberty interest. What state was that? California. Yeah, amazing. A public office is not property in the constitutional sense, and the right to be appointed to a public office is not a property right within the protection of the Due Process Clause. Right, well, a lot of case law here. Okay, I'm sorry, case citations 2001, 10, 8, so a lot of very current case holdings here. And Section 14 is the absence of contractual relationship arising from public employment or office. And let's just briefly check over here in the chat if we have anything new in the chat. All right, let's continue here. An appointment or election to public office does not establish contract relations between persons appointed or elected and the state. Public employment does not give rise to a contractual relationship in the conventional sense. Neither does an appointment or election to public office establish a contractual relation between the person appointed or the elected and the public. Indeed, the nature and scope of public office fundamentally transcends a mere contractual relationship. On the other hand, when agreements of employment between the state and public employees have been adopted by governing bodies, such agreements are binding and constitutionally protected. Thus, where the employment relationship is governed by contract, a public employee's breach of contract claim is not simply defeated by his or her status as a public employee. Ooh. Accordingly, with regard to at least certain terms or conditions of employment that are created by statute, an employee who performs services, while such statutory provision is in effect, obtains a right protected by the contract clause, under both the state and federal constitutions, to require the public employer to comply with the prescribed condition. That's footnote 6. Statutory provisions controlling the terms and conditions of civil service employee cannot be circumvented by purported contracts in conflict therewith. Controlling terms of civil service employment. Federal workers serve by appointment, and their rights are therefore a matter of legal status, even where compacts are made. In other words, their entitlement to pay and benefits must be determined by reference to the statutes and regulations governing compensation, rather than to ordinary contract principles. And that's Wade versus United States in 2018. All right, interesting there. And we have public offices created by constitutions, Section 15. A constitutional office is one created by the United States Constitution or by a state constitution, as distinguished from an office created by statute. While state constitutional officers are creations of the state itself, a reference in a state constitution to a particular position does not automatically render that position a constitutional office. So, would a FOIA officer, is that designated by statute or by the Constitution? I think that's a statutory one, right? The legislature's power over constitutional offices is limited. A legislature cannot abolish a constitutional office, nor can it change such an office except as expressly permitted by the Constitution itself. The legislature may, however, grant additional powers to a constitutional office by statute. Also, while constitutional officers may perform certain functions in conjunction with local government, they are neither agents of nor subordinate to local government, and a local government has no control over their work performance. So constitutional office officers may perform functions in conjunction with local government, but they're neither agents of nor subordinate to the local government. The local government has no control over their work performance. So here's our observation. Where county sheriffs are state constitutional officers, the deputies they appoint are also deemed to be state officials rather than employees of the counties in which they serve. Ooh. With the effect that deputy sheriffs are not subject to the merit system covering county employees or to the personal policies covering termination of county employees. Wow. So that's an interesting observation on sheriffs and their deputies, that they are deemed to be state officials rather than employees of the counties in which they serve. Are not subject to the merit system covering county employees or personal. Yeah, interesting, merit. I think that was called the quota system. Wow, applying Alabama law here in footnote 10. That was it. That's the Alabama law there. Wow. And that brings us to the end of this presentation, because now we're on to the federal elements here, which is a whole nother subject. So with that, I'd like to thank everyone for attending here tonight and learning about the nature of the public officers and public employers and how we make that distinction, and will really help us in dealing with instances where perhaps the efficiency or the effectiveness of these people that are entrusted with a public duty may fall short of our expectations, and proper ways to address it that are legitimately within the facts, within the laws, and not necessarily with stupid policies and codes, but rather things that have a little bit more bite to them. So you can't get rid of the sheriffs. Well, not through a merit system employment. I guess the sheriffs have a tenure, so a certain time they have to serve. They can be removed for other reasons, though. So they stole the sheriff because of the post to be for the people of the last defense from tyranny. Yeah, so that's really what the sheriff is supposed to be for. So indeed, Diesel had a point there. Oh, well, thank you so much for coming here and contributing. This is what it's all about. We all want to try and learn some of this stuff together to better apply the privileges that have been bestowed upon us, and that we should reciprocate for the posterity. Nowhere else in the world are we able to even discuss these kinds of things in a meaningful way that would apply to our lives. It would just be conjecture. So salute to all of you for being here to exercise your American duties and rights, and to really enjoy the benefits that the American experiment has presented to us. And let's see if we can keep it going for another generation at least, and hopefully much longer than that. With that, I'd bid you all farewell and see you all on the next one. Peace out.